Good morning, everyone. My name is Stephen Richardman. My ID is DEM09190223. Now, I want to present my part is definition and purpose charge. First is notice to the accused. Notice to the accused must be conveyed with sufficient and clearness and certainty. Second is criminal charge. Criminal charge is a formal accusation made by a governmental authority, usually a public prosecutor and or the police, attesting that somebody has committed a crime. Third is inform the accused. Inform the accused of the offense alleged against him and for him to prepare his defense.
Of charge in Section 152 Criminal Procedure Code contains several conditions, namely, the charge must precisely state the offence, both state the law and punishable section of the law can carry out punishment. Second, the time and date of offencer applies. Third, the place in which the following incident took place. The latter, particular of the thing of instance, just as serious number of the pistol, color, or registration number. It was had the full definition of the offencer, which is the honestly receiving stolen property, where the accused know or has reason to believe to be stolen.
Assalamualaikum. My name is Fazul bin Ahmad. My ID number is DEM111902. So today I would like to present about form of charge. In this charge, under this code shall be state the offence which the accused is charged. If the law which creates the offence give it any specific offence may be described in the charge, may that name only. If the law which creates the offence does not give it any specific name, so much of the definition of the offence must be stated as to give the accused notice of the matter which he is charged. The law and section of the law against which the offence is said to have been committed shall be mentioned in the charge. The fact that the charge is made is equivalent to a statement that every legal condition required by law to constitute the offence charge was fulfilled in the particular case. If the accused has been previously convicted of any offence and it is intended to prove that previous conviction for the purpose of increasing the punishment which is the court is competent to award, the fact that a place of the previous conviction shall be stated in the charge. If the statement is committed, the court may add it at any time before sentence is passed. One of the case under Section 158 of Criminal Procedure Code, any court may alter or add charge at any time before the judgment and must explain to the accused. Case of Kamaruddin Mad, DDV PP 2005, 3 CLJ 180, accused was charged for raping his stepdaughter of numerous occasions. At a close of prosecution case, the session court judge amended the date of the alleged rape. He was found guilty, convicted, and sentenced to 18 years imprisonment. His appeal to the High Court was dismissed, and he then appealed of court. Then he appealed of the Court of Appeal ground of appeal. The charge was not treated to him after it was amended at the close of the prosecution case. COA dismissed the appeal and held that although the charge was not read immediately upon its amendment, it was subsequently read before the session court judgments.
Assalamualaikum and hi, my name is Nur Aisyah Zwani binti Mak Samsuri from DEM 1019017. Example of the charges under Section 302 Penal Code on November 25, 2040 at about 9:50 p.m. at Kampung Sentosa, in the district of Miri, Sarawak, committed murder by causing the death of one is Ali Musa and have thereby committed an punishable under Section 302 Penal Code, the Act of 80, subject to Children 2001.
Hi, good morning. My name is Shazmi bin Shafari, DEM 1019-007. Example of charge: theft of a motor vehicle under Section 379A of Penal Code, that due on January 16, 2017 at about 9 p.m. at number 1 Jalan Cergas in the Federal Territory of Kuala Lumpur committed theft of a motor vehicle. Plate registration WWF 1121 worth RM 20,000 and Teribi committed an offence punishable under Section 379A of the PC. The offence is charged under Section 379 of the Penal Code and read in conjunction with Section 34 of the Penal Code, which provided for a maximum sentence of 7 years imprisonment and a fine.
Assalamualaikum and good evening. My name is Muhammad Sufian B. Amir. Today I will present the error in charges. When we sit at a council table, we are feeling so satisfied and we have to preparation was intense. After that, the witness our present on behalf of the plaintiff were strong and accurate from our cross examination. If we say for ourselves was magnification. And everything about the trial went just the way from our expected. Next, the first at all, we have to got the object. After that, when the instruction was complete, we have raised our hand and say what's wrong with the charges. And if the judges say they no agreement, we we have to we must dig in our head and respectful in test just what we heard. Next, in section 156 of criminal procedure code, there no error in stated of offense or particular in the charge should be regret as violent error unless accurate was fake misled by such error. For example, Ali is charged with cheating the bad rule. And the manner which he cheating bad rule is they no set in charges. Then there were many instructions between Ali and Badrul, and Ali had no mean of knowing which to which of them judge refers to. The court may inform from instance fact the failure of set out the manner of cheating was violent errors which caused the failure to charges to accused. Thank you.
Amendment of charge. In determining whether an amendment to a charge sheet or indictment will cause prejudice to the accused, the court should consider the stage of proceeding at which the amendment is sought. The effect of the order should be not on the charge sheet or indictment. Failure to do will not, however, deprive the order of any effect. A charge sheet or indictment that is amendment is treated as if it were filled in the amended form. However, if a charge sheet is amended in the magistrate court and then subject to an appeal to the country court, an appeal against conviction and sentence is treated as an appear against the charge sheet as original, filed without any amendment, will an appeal against sentence alone is treated as an appeal against the charge sheet in its final form. The statutory amendment power is wide-ranging and allow amendment that add charge, substitute applicable charge for inapplicable charge, and add or vary the particular of an offence. It is not necessary that the original charge sheet or indictment correctly set out the essential element of the charge of the relevant statutory provision before the amendment power can be exercised. The power to amend the indictment extends to all offences, including common law offences such as perjury. The power to amend a charge sheet or indictment includes the power to reduce the period of the accused alleged offending in a course of conduct charged with the meaning of Clause 4A of Schedule 1 of the CPA 2009. This power applies when the accused informs the court that he will plead guilty to charge if it relates only to the specific period falling within the period to which the original charge relates, but will not plead guilty in respect of the remaining period in original charge. A court may only amend a charge outside the limitation period of the charge sheet before the amendment sufficiently disclose the nature of the offence. Next is the amendment does not amount to the commencement of proceeding for a new offence, and the amendment will not cause injustice to the